All right. Well, welcome everyone to the newest edition of Trustee School. This is the first Trustee School in about 5 years where we've had the opportunity to have some in-person guests since COVID. So this is our first ever dual Zoom and in-person. So this is exciting. But hopefully there's no technical glitches that we
Are
can
you okay there?
just move forward with all this. Um, with that being said, welcome. Let's just get started. This is Trustee School, October 4th, 2025. Everything you need to know about being a trustee of a special needs trust. So our goal is, to review the basics of government benefits. Our clients with disabilities, they have needs-based benefits such as SSI, Medicaid, food stamps, HUD housing, Medicaid waivers, whether that's through the Developmental Disabilities Board, whether that's through Job and Family Services. We're going to review those benefits. We're going to explore the relationship between those benefits and trust administration. The trust administration with special needs trust, whether that's a first party trust, whether that's a third party trust, and we'll get into the differences between those types of trusts. And then we have to understand what the trustee responsibilities are, them managing these funds for their loved ones. And a big component of what we provide as a firm is the use of care managers to ensure quality of life, especially when the our trustees who the parents who have passed away or are unable to care for their loved ones, well, who is going to take care of the day-to-day aspects for their children, grandchildren, and so forth. So one of the first things, a typical situation is, hey, my mom passed away, and now I'm taking over this management of this trust for my sibling or my other loved one. Where do I start? I always tell clients, well, you need to read the document. I know that's pretty straightforward, but read the document and write up your notes, your comments, on the side of it and say, okay, what does this mean? What do I have to do next? Well, reading the document is imperative to know what's going on, who's in charge, who's the beneficiary, what are my responsibilities according to the trust document itself. Then you need to meet with your attorney, whether that's us, whether that's some other attorney, you need to meet with an attorney to help explain and guide you of what your next steps are. You know, as responsibilities as trustee, this is not just a typical trust. These types of trusts that we create and that we help manage for clients, these special needs trusts. Any trust has, management of assets for a beneficiary. Our trusts have that added responsibility of caring for someone that is in a vulnerable population. This is a very disabled, individual that can't care for themselves. So there's added responsibility to that because they are on benefits. How are we going to protect those benefits and supplement them with these trust assets? But generally speaking, trustee responsibilities, include, investing the money, dispersing the money for the benefit of the beneficiary, record keeping, the reporting requirements to governmental agencies such as Social Security, Job and Family Services, to the Developmental Disabilities Board, and like everyone, paying taxes. Um, With our special needs trusts, there's the advocacy provisions that we put in our trusts that we are also caring for the the livelihood, the day-to-day aspects of this child, this loved one with disabilities. If the trustee has or is representing that they have, some kind of specialty, whether the trustee is an attorney themselves or an accountant or a financial advisor, well, the law makes it clear that they have an extra, heightened duty because they are representing themselves to be, not a layperson. So that's something to keep in mind that, if a child does have, a law license or an accounting license, well, they should know what they're doing. And so the law is going to say you should have known what you're doing in this circumstance. Generally, self-dealing with a trustee should not be explored. We frown against that because self-dealing has the implication that the trust is benefiting the trustee and not the beneficiary. So we want to make sure that self-dealing is limited as much as possible. So we suggest don't borrow from the trust. Don't invest your business in the trust. It- don't borrow money from the trust to invest in your business, for example. Don't purchase an item or purchase a house from the trust for yourself or for the benefit of your family, unless it's, an arm's length transaction. Um, and don't commingle your assets, the trust assets with the trustee's assets. And with that, don't commingle the beneficiary's assets with the trust assets. Keep everything separate. It just makes it a clearer picture that this is the trustee's assets, individual assets. This is the trust assets. This is the beneficiary's assets. So commingling of any assets together is just not a good idea. With a fiduciary duty, though, there is a duty to delegate. You're not responsible for managing every aspect of the trust. So, yeah, you can hire an attorney, you can hire an accountant to do the taxes, you can hire a financial advisor to help with investing. The idea, though, is, well, you should manage those delegations. So you should have review meetings. You should have you should have meetings with these professionals to review, okay, what are the tax implications of doing this transaction? What's the tax implications, at the final year? Um, so delegation is key because not everyone is um, an expert at everything. Most people aren't. So we want to make sure that, you know, we're touching all bases of the trust. Um, that includes, even hiring a care manager. So an advocate for the beneficiary, especially when the trustee is not in town, to see the beneficiary on a regular basis. Well, you can delegate that authority to someone else to check in on that beneficiary and report back to them. I touched on this a little bit about investment. Yes, you should invest the property, the trust property with, using the Ohio Prudent Investor Rule, which uses the modern portfolio theory. It depends on what the circumstances are, what financial advisors really touch on is, okay, what is the age of this individual? Um, what's the life expectancy of this individual? What are the care needs of this individual? What kind of does the trust need to expend $10,000 a month, for care needs or more? So there's riskier investments, conservative investments that a investor will use, but it all depends on the circumstance. The good news is the law says, hey, we're gonna use the prudent investor rule so you can easily manage those expectations. Um, Delegation, once again, can be made to a reputable financial investment advisor to help diversifying assets, having a CD and a brokerage account, a checking account, so forth. What really sets
Could we mute everyone, please?
yeah, let me see if I can mute myself.
What did you say?
Make sure
Yes,
we keep everyone's muted during the presentation so there's less background noise. So reporting requirements, we want to make sure that the trustee, when a beneficiary is receiving benefits, that reporting requirements are being made to the appropriate governmental agencies. And that includes taxes. Obviously, we're gonna, if the trust needs to pay taxes, yeah, we're gonna have to file a tax return. We're gonna have to pay, quarterly taxes, annual taxes as necessary. Um, Accountings to the beneficiaries. Ohio law says that the trustee does need to account to beneficiaries, unless it's waived by the trust. Some trusts do waive that reporting requirement. But like I said, what sets these trusts apart from typical trusts is, yeah, these beneficiaries are on benefits with Medicaid and Social Security. And when their annual redeterminations come up to determine, hey, does this person still qualify for Medicaid? Do they still qualify for Social Security? They're going to ask for the trust document, they're going to ask for the trust statements, and they're going to question disbursements possibly from the trust. What was this $500 payment that was made July 2nd of 2025? And you as trustee are obligated to provide that. If you don't provide it, then they're going to say, well, we don't have this information. We can't verify that the trust is being used appropriately, so we can terminate the beneficiary's benefits, which, it's a lose-lose for everyone involved. So reporting to governmental agencies are, crucial and critical for the trustee to do. We just had this slide here just as an example for trustee compensation. So typically, trust language in our trust say, well, what is the compensation for the trustee? Well, it's paid annually, and they the trustee should look at the local probate court to determine if this trust was governed under that local probate court, look at their fee schedule that they have in place. And many courts, they have a complicated arrangement of looking at the principal of the trust, looking at the income of the trust, and what kind of disbursements have been made from the trust. And it works out with this formula, which is then, equal to what the compensation should be for that year. But this is just an example. And if the trustee is doing extraordinary measures, well, yeah, the trustee can be paid a little bit more than what the fee schedule permits. It's all taken at what is reasonable under the circumstances. Special challenges with managing a special needs trust. You know, we know that the beneficiaries have limited and diminished capacity. Maybe they are incompetent. Maybe they're under guardianship. Maybe they are not under guardianship, but they do have limited capacity where they need help with managing their finances and, you know, helping going to the doctor and medical needs. Um, the state may be the beneficiary as a payback to the state of the trust at the beneficiary's death. And that's what we see with a special needs trust, a first party special needs trust, where it's a Medicaid payback trust. The beneficiary might have low income themselves, or they might have high income. And how do you manage, you know, using trust assets compared to what the individual has themselves? How are things going to be paid for rent and food and their other maintenance needs? There could be involvement with the court. If this is a court administered trust, then this is more complicated because now we have to have court supervision of the trust. Typically, we see court supervision when the beneficiary is under guardianship and they have received money like an inheritance or a personal injury suit. And so the court has jurisdiction over that trust money. We typically do not see that with a third party trust, a wholly discretionary trust, where the client has created a trust for the beneficiary and has set aside money for that beneficiary and has appointed a trustee. We typically don't see that with a third party trust. Other challenges, looking at caretakers for this individual, and the caregiving needs of this individual, securing services and equipment. We see that all the time with, our clients getting a Hoyer lift, getting a wheelchair, getting all kinds of medical equipment that this individual needs. Should that come from the trust? Should that come from Medicaid, through their DD waiver or through their Ohio waiver with Job and Family Services? Redirecting family and caretakers and beneficiaries, getting everyone on the same page, caring for this individual. Sometimes you might have family members, butting their nose in when they shouldn't be butting their nose in. And sometimes you have family members that should be, but just aren't. And sometimes all the responsibility is on that one trustee to help care for the individual, which causes a lot more stress for that trustee. As part of our, planning, when we meet with a client, we tell them to write a letter of intent. A letter of intent is not a legally binding document, but a letter of intent is a very important document as part of the estate plan to show to the trustee, to beneficiaries, to family members of why we created this trust, what you foresee trust administration for the beneficiary after they pass away. What are the quirks and nuances of the beneficiary? What do they like? What do they dislike? We put that into a letter of intent so the trustees and family members know what's going on and what should be going on, after they pass away. Generally, we're going to get into more specifics about this, but just generally, trust administration disbursement rules, particularly when people are on needs-based benefits like Medicaid and SSI, we recommend and we try to enforce to our clients and our trustees, make payments directly to the providers for goods and services. Don't send $5,000 to their account to help pay for that Hoyer lift. or wheelchair or, rent money. Make the payment directly to that third party. No cash to the beneficiary because Social Security and Medicaid, they have very broad rules of what income looks like. So in money coming into their account every month, whether that's $100, whether it's 500, $1,000, if they see money coming into that account, they're going to count that as income. And so that might disrupt their benefits. These are presumptive rules, meaning they're not absolute. So there's going to be, wiggle room about, how to make payments, but these are just general rules of how to disperse money from the trust for the benefit of the beneficiary. All right. I'm just checking the chat box to make sure. All right. Trust assets. We make a slide here dedicated to the residence because, the residence is a very important topic for our clients and for the beneficiaries. Sometimes it's the parent's intent to have the beneficiary remain in the home as long as possible. But issues might arise where you have to have care providers come into the home. There might be roommates to lessen the cost of the upkeep of the home and to just have, better providers in the home. If you have roommates, well, you can have a provider coming into the home to help care for, two or three people instead of just one person. Um, Maintenance and affordability. Yeah, having a home, we all know, owning a home, you have to repair the roof, repair the sidewalks, repair the furnace when it goes out. It can become quite tedious and expensive. And insurance. So we've got to make sure that insurance is kept on the house, of course, because if a tree falls down and wrecks the garage, wrecks the house, we have to make sure that the trust property is being cared for. But insurance is also looking at liability insurance because if we do have caregivers coming into the home, if the caregiver, trips and falls, breaks an ankle, we want to make sure that they are compensated through the insurance, not being sued from the trust, the caregiver suing the trust and depleting trust assets. So insurance is a very important component of owning a home, especially when a trust owns the home. Vehicles, another important topic that our clients look at. We typically do not recommend vehicles be titled into the trust name, and that's for liability issues. However, the title should be put into either a family member's name, the beneficiary's name, or sometimes even a caregiver's name. It all depends on the circumstances, of course. I typically don't recommend a caregiver, but it happens. It sometimes makes the most sense, but the trust will always hold a lien on that title. So there's always going to be um, protection for the trust that if the car is totaled or if the car is in an accident and they're sued, well, it's not going to back on the trust because the trust doesn't own this vehicle. They just have a lien on this vehicle. It also adds protection that if this person ever does, who's the owner of the vehicle, decides to sell the vehicle, well, they can't just sell it. They have to, because there's a lien on there has to be a release from the trust before payment is being made and title is transferred over. Insurance, obviously, that's the other reason why we want the third party, whether that's a family member or um, the caregiver, whoever, is the trust can pay for insurance, life insurance on that person's life, so that if that caregiver does pass away, that family member does pass away that's caring for the beneficiary, then it can be reimbursed to the trust to help pay for a new caregiver. Um, Another important asset that the trust provides and pays for is a prepaid funeral plan. Not a fun topic, but it's necessary to do so because if this is a first party special needs trust with a Medicaid payback provision, beneficiary dies and doesn't have a funeral plan, you have to ask the state for permission to pay for the funeral. You can't just, beneficiary dies, you can't just go pay for a funeral. You have to get permission from the state to pay for the funeral. Typically, the state of Ohio will allow for the trust to pay for the funeral, but I've seen that they disagree with the price. So you have to, lower the price of the funeral. Doing that now, while the beneficiary is alive, just creates less headache in the future. So that's something that a trustee will always, should always be one of the first things that they do is just purchase a pre-need funeral plan, and that way it's just done. Oh man, we're in the fun topics of the presentation. Oh, I have a question here. If the trust buys a prepaid funeral, is it an asset of the trust or the beneficiary? It's actually an asset of the beneficiary. And a beneficiary can have a pre-need funeral plan and be on SSI, be on Medicaid. That is an exempt, non-countable resource. So, 99% of the time that is in the beneficiary's name, that pre-need funeral plan. So taxation. So I am not a tax attorney. I'm not an accountant, but I do know the general, gist of taxes with trusts. If this is a self-settled trust, meaning that the beneficiary has received this money and they put this money into the trust. So they created this trust. Typically, this is a Medicaid payback trust. This is a special needs first party Medicaid payback trust. And you notice there's multiple names that we give this type of trust. So if you hear me say Medicaid payback, a first party, same thing. Self-settled, that means for tax purposes, all the income that's earned by the trust can actually be carried over to the beneficiary's individual tax return. And that's good because trust tax rates are much higher than an individual tax rates. You have to make over $500,000, in 2025 to be in that 37% tax bracket for an individual, but just make over $10,000 for a trust, you're in that 37% tax bracket. So instead of the trust paying, the taxes, you can carry that over to the beneficiary's tax return to pay. And that's done through a K-1, where the income is carried over. Taxes for another slide about self-settled. So the question that might become is, well, Ethan, I'm putting income to the beneficiary on his tax return. Isn't that going to disrupt his benefits? Well, there's a difference between taxable income and benefits income. And just because it's going to be on his tax return, it's going to say that he made all this money. He didn't. It's the trust. And that's why there's the K-1 to prove that. He didn't make that money personally. It came from the trust. So that wouldn't have any detriment to their benefits because it's on the individual tax return. But as a reporting requirements for the agencies, because the caseworkers, they're not there are very smart caseworkers out there, but there's very new caseworkers, as we know, dealing with the DD boards, dealing with Social Security and Job and Family Services. It's a high turnover field. So a new caseworker is probably not going to know this. So that's why retaining all evidence of distributions from the trust, retaining the statements to prove to them, showing them the tax return, explaining that, you know, that's all that you can do. And hopefully that's enough. And if not, then you have an attorney to explain it to them and, rough them up a little bit. Third party trusts, though. So taxation for third party trusts, a little different. You can't carry over all the income to the beneficiary, but you can carry over what's called distributable net income. So what that means is the income that the trust generates, if the trust has made any distributions during that time, during that year, that amount of distributions can be carried over to the beneficiary. So as an example, let's say the trust makes $20,000 in income. That's capital gains, interest income. Well, $20,000, they're going to pay a pretty big tax bill with that for that year. Well, if the trust made $15,000 worth of distributions during that tax year to the beneficiary, well, that $15,000 of income can be distributed to the beneficiary through a K-1. So instead of a $20,000 tax bill or taxes of taxable income, now it's $5,000. There's also exemptions that a third party trust can use because this would be considered a qualified disability trust, so there's a higher exemption. There's ways of getting those tax liabilities reduced down to zero, but there's just lesser ways to do that with a third party trust compared to a first party trust. So as I spoke at the beginning of the presentation about care management services, what we see in why we hired a care manager, a care coordinator for our firm is we saw a gap in services where mom and dad passed away. They had 3 children. One of those children were disabled. They're living in a group home. They were being cared for, but the other 2 children, they live in California. They live in New York. They don't live in the area. So who's going to, keep an eye on this child? They're not going to move to California. They're not going to move to New York. They're pretty stable in Ohio, but the siblings are the trustees, or they might even be the guardians. But how do we keep an eye out on this disabled loved one that's living in Northeast Ohio, in the area? Well, that's what the care manager's role is. We have a care manager. There's other care managers, companies out there as well, but that's their duty is to go check in on them. Are they receiving the services that they need to receive? Are they being heard? Um, are they do they want something? Do they want to go to, a Guardians game? Browns game, probably not, but maybe even a Cavs game. That's what the care manager can report back to the trustee, act as the middleman between the beneficiary and the trustee, a middleman between the DD board and the trustee, sit in on ISP meetings with the DD board. They fulfilled that role that was carried out by the parents, but now the parents, are gone. They act as an advocate, identifying problems, offering solutions, while encouraging as much independence as possible. They want to make sure that this individual is being cared for, as much as possible. Cost of the care manager, our care manager is paid by the hour. Um, Her rate is $180 an hour. So a, that could be a few $100s a year. It could be a few $1,000s a year, depending on what the care needs of the individual would be. And it can be as extensive or, hey, can you just check in on them, a couple times a year and just report back? Or it could be, hey, you need to check in on this person, every week, whether that's a phone call, whether that's, a meeting, it can be as extensive as the trustee wants it to be. So I touched on this, making visits with the beneficiary. What do the care managers do? Recommend placement, recommend providers, recommend caregivers, especially when caregivers do decide to leave. Well, now there's a gap here. What are we going to do? Do, do they need to be placed somewhere else? Do they need to go to a facility? Do they need to go to assisted living? Do they need to go to a new group home? Um, Ultimately provide an annual care plan for the trustee to detail, hey, this is what, work on a budget for the beneficiary. This is what they want. This is what they need. Um, Care managers are accountable to the trustee because the trustee is the one that's in charge. So they're the ones that are hiring the care manager. So the care manager reports to the trustee. Like everything else, the trustee can delegate, hey, I'm the trustee, but can you talk to my care manager, talk to my sister, because she's better with, the care side of things. I'm more the financial side of things. So talk to this loved one and we can all work together. So delegation of duties can be done, throughout. So we talked about her. Our care manager is Andrea Thoreau. Um, she's a licensed social worker. She's before she came to Hickman and Lowder, she was at Western Reserve Area Agency on Aging. She worked a lot with on the hospice side of things. She has a lot of gerontology experience. And she's got a lot of disability experience as well. So she's great. If you haven't met her, feel free to, give her a call and, talk to her. Um, Now segueing here, reporting requirements to benefit agencies. So like I said, there's a lot of reporting requirements, at least annually. If they're not doing it annually, sometimes, especially with Social Security, we've seen, with when the person's on SSI, they might require reporting, every month, especially if the person's working. We see that all the time. It it can be the luck of the draw. I don't know. The caseworkers at Social Security are very unstable when it comes to that with reporting. Some people have no issues with Social Security. Other people, they are through the ringer with them for years before everything can be straightened out with them. Um, the idea is if they ask for something, give it to them. They are the ones that are providing funds, whether that's through Medicaid insurance, whether that's through caregiving, whether that's actual money through Social Security. And the only reason why they are receiving these funds is because they have a low income, low assets, and this trust is an exempt asset. So they want to make sure that the trust is being used appropriately before it's before benefits are given to this individual. All right, I'm going to wait for this question in the middle. Social Security requirements, with reporting. If there's a change in circumstance, technically you have 10 days after the end of the month where that change has occurred to report that to Social Security. So whether that's a change in living arrangements, change in the income, change in countable resources, if they receive some kind of settlement or inheritance directly to them, well, they need to be notified that within 10 days at the end of the month where the event occurred. Change in marital status, change in medical improvements. Maybe they're not disabled anymore, according to Social Security, um, or they've become worse. Any trip intended outside of the United States, if this person's receiving SSI or SSDI, you have to inform them that, yeah, they're going to Canada for, a vacation. Or any trip outside of the United States, they need to be notified of. If there is an issue with benefits, whether that's with Social Security or with Job and Family Services, these are, there are due process rights that the beneficiary has. And if there's a denial, you need to notify an attorney right away because you can appeal that. If an appeal is made immediately, within at least 10 days of the receipt of the notice, benefits will continue until the issue is resolved. You are allowed to appeal up to 60 days, but if you wait after that 10 days, the benefits may be stopped. And then if they're stopped, you have to go through the appeal process to get it back going. So if you appeal before that 10 days, income and benefits will be continued. So just in general here, as a reminder, we need to update and review the estate plan, as as often as we should. We recommend at least every 3 to 6 years. But if there's a change in, in the beneficiary's care, the beneficiary's health, the change in who, is administering this trust, if there's a change in family circumstances, note, and this is while the parents are alive who created this trust or after they passed away, it's always good to have an updated meeting with the attorney to just update them on the situation, whether any changes to the plan, whether changes to the trust or the trust plan should be made. So it's important to just update that with the attorney every 3 to 6 years, just so everyone's on the same page, and things usually need to be tweaked, in that time. All right, so we talked about trustee duties, obligations, responsibilities, reporting requirements. Why do we have these trusts to begin with? Well, these trusts are here to protect our beneficiaries' benefits. And what are these benefits? Well, first, let's talk about Social Security. To be disabled under Social Security terms, you have to be physically or have a mental or physical impairment. It has to last at least 12 months or longer or result in death. And these are taken from, this is the definition from Social Security. And the disability prevents engaging in substantial gainful activity. So SGA. What SGA is determined is, can this person make more than $1,620 a month? If they can make $1,700 a month gross, then even though they are disabled, they're not disabled under Social Security standards then. To be receiving SSDI, that's Social Security Disability Insurance, you have to be disabled, under Social Security's definition. And you have to have enough work credits, work quarters to receive it. So if you have at least 40 work quarters, you are entitled to receive your full Social Security disability check. Or you can be a dependent, a disabled adult child off of a parent's work history. And I'll get into that in the next couple slides here. But there's so that's two ways of receiving SSDI. Either you've worked yourself and then you become disabled, or you're disabled before a certain age and you can take SSDI checks based off of a parent's work history. Once you're approved for SSDI, if the Social Security says yes, you are approved, you will receive a check 5 months after that disability determination. You will then receive Medicare 24 months after that first SSDI check. Why is there a lag? Well, the hard truth of it is the government is waiting for you to die so they don't have to provide you with that insurance, with that check. So they're saying, well, there's a probationary period here of 5 months for money, 24 months for insurance. If you die in those months, well, the government is not going to give you out any benefits then. This is not means tested, but the SGA is relevant. That's 1620 a month. If you are making more than 1620 a month, then you won't receive SSDI or Medicare. So the childhood disability benefits, SSDI, if Social Security has determined that this child is disabled before the age of 22, and the parent has retired, become disabled themselves in receiving SSDI, or they have died, they can receive benefits from their parents' work history. So it's always important when I meet with a client that their child is turning 18, that go apply for Social Security now when that child has turned 18, because they will qualify for SSI when I'll get into that. But you have that determination from Social Security that they've been disabled prior to the age of 22. That's on the books, it's in the records. So that way, when parent does retire or die, then they will be shot up to the SSDI limit. They will receive more money based off of their parents' work history. It just makes it a lot easier with that transition. SSI, different from SSDI. SSI is supplemental security income. Same definition of disability, but there is no work history for this individual. So think of the person that just became age 18, they're disabled. Well, they don't have a work history. They will take, they'll go through the SSI approach. Right now, that's $967 a month that they are entitled to receive. SSI and Medicaid are mirrored. Generally the same eligibility standards. They look at countable resources and income levels to see if they qualify for SSI and Medicaid. So this is a time to look at questions that I missed. So one here is, both of my children are beneficiaries to an irrevocable trust and a special needs trust, and I am the trustee for both. My younger son passed away last year, and my older son is adult age now, and I am also legal guardian person for him. Is there anything that I need to do to update, change the trust? Yes, I think that there would be. There is, depending on what the trust says, it probably has provisions in there to account for if the beneficiary had passed away and who's the successor or contingent beneficiaries. For SSI, what is the income level that reduces the 961 a month? I'll get into that a little bit more. It's 967. That's the maximum SSI that one is entitled to. But if the person is receiving free shelter by living with um, a parent or um, receiving help with shelter expenses, that's called in-kind support and maintenance. Or if the person is receiving income from another source, whether they're working a little bit, or they're receiving, a survivor pension, that will reduce their SSI as well. And I'll get into that a little bit more here soon. All right. So this is like generally speaking here, income versus resources, because there's many times where clients confuse those those simple terms. Income, receipt of assets for Social Security purposes is income the month it's received. So, as an example, they receive a $10,000 check from a long lost uncle who had them as a beneficiary on an account. That will be income for that person the month that they receive it. If it's still in their account the next month, now it's considered a resource. So there's a 10-day reporting requirement, like we said. Examples, inheritance, interest, wages, that's income the month it's received. It becomes an asset the next month. So this is for SSI purposes. I should first say deeming. There's a bullet point there for deeming that if you have a disabled child who's a minor, technically they qualify for SSI. But because their parents' work history, because they're working, parents have assets, parents' income and assets deemed to that minor child. It's only until they turn age 18 that they qualify for SSI because now parents don't deem to the child anymore. They're their own person, they're a legal adult. Um, with that being said, then, so income for SSI. If a person is receiving income, whether that's earned or unearned, it goes through this formula with Social Security where, okay, the first $20 of unearned income is disregarded. For earned income, the first $65 plus one half of the earned income is disregarded. There's also impairment related work expenses that are disregarded. So if they need, equipment to do their job, that payment would offset their income for that equipment. Um, the in-kind support and maintenance, if they are receiving help from a third party, like a parent or a trust, and it's paying for shelter expenses, that will reduce their SSI as well. So there's many reasons of why income is reduced, their SSI is reduced if they're working, if they're have unearned income such as like a pension, or they're receiving help from a third party, that's going to affect their SSI. Resources for SSI purposes, a resource has to be owned by the individual, but also available to the individual. I had a case recently where the individual was 18 and a grandparent who was now estranged, they set up an UTMA account, Uniform Transfers to Minors Act account, where it was when the child turned 21, they would get this $5,000 in this account. The grandparent was the custodian of the account. Well, technically, that account was owned by the 18-year-old because it's in their name, it's under their social security number, but it's not available to that individual. He can't go to the bank and withdraw that money because it's under a custodial account. So even though it's owned by it, it wasn't available. So two two aspects there. It has to be owned and available and not exempt. What does that mean, not exempt? Well, I'll get into that on the next slide. We talked about deeming, where a parent's income and assets deem to the minor child. Exempt resources. So exempt resources, these are the main ones. There's a lot of little things, but these are the main ones. Household goods and clothing are exempt. The residence, as long as it's their primary residence, that's exempt. One vehicle is exempt. The irrevocable funeral contract is exempt. And there was a question about the pre-need funeral value. There is there's no limit to that, as long as the an issue might come up where you assign an insurance policy to a funeral contract, where the funeral contract is like $10,000, but the insurance policy is $30,000. That's where you come up with an issue. I have a couple more questions here. I'm going to tackle these questions. How much does it cost to update a family trust, special needs trust? That all depends on the situation. I can't really give you a number. It could be a couple $100, could be a couple $1,000. It depends on what needs to be changed. If a child qualifies for SSDI under a parental security, will SSDI continue after 18 or switches to SSI if the child is not working? So it won't switch to, once you qualify for SSDI, you will continue receiving SSDI. It won't be switched back to SSI. The SSDI is the higher amount, and you would never be reduced. Illinois started from prices during reset and how property planning needs to be careful at risk in your fee. Okay. I'm gonna have to look at this a little bit more. All right. So let's go back to the exempt resources here. Burial plots, same thing, those are exempt. Whole life policies are exempt with the total face value with all the policies have to be below $2,000. So that's very limited circumstances. Back payments from Social Security, you see that a lot. It's exempt for 9 months. So if you receive $20,000, well, that's exempt for 9 months. And obviously, special needs trust, pooled trust, discretionary trust, and able/stable accounts. Okay, so let's say the parent who is paying child support to a disabled person, like a castle child, is thinking of retiring. What is the interaction between the parent's court-ordered child support obligation and possible benefits through SSDI under parent's Social Security? Well, the child support, I think that we talk about that a little bit here. Child support is After a child turns 18, generally child support stops. If the child is considered a castle child, meaning that this child is disabled, then the child support can continue for life for that individual. Um, at age 18, if child support is continued to the castle child, it's considered income to that child. So what we recommend is that child support payments be paid to a special needs trust instead of to the individual directly. So that has to be done um, through the court, whether that's juvenile court, domestic relations court. You have to get a court order saying that the child support is being paid to the special needs trust. If it's paid to that child, well, that's going to be, a problem if that person's on SSI and Medicaid. It's going to kick them off their benefits. So we work with domestic relations attorney, divorce attorneys all the time to ensure that, okay, if child support is continuing past age 18, then it's going to be, put on there, put directed to the trust and not to the child themselves. All right, so yeah, at age 18, child support, although it's paid to the parent, it's considered income to the um, child under Social Security standards. All right. So Medicaid. Medicaid provides obviously insurance. If you're on a waiver with Medicaid, they provide health aids, caregiving, prescription drug coverage, equipment, and this is administered with your local county job and family services. Like SSI, Medicaid is a means tested service benefit. Your accountable resources generally have to be less than 2,000. Income generally, below that SSI limit, 967 a month for an unmarried individual. Medicaid waivers. What does that word mean? What does waivers mean? So generally, the federal government is providing Medicaid dollars to institutionalize people, meaning they have to be in a nursing home or an ICF, intermediate care facility. But with the caveat that each state can waive that requirement of institutionalization. So what Ohio and what most states have done is, the cost of care, the cost to care for an individual in an institution is far greater than if they were living in the community. So they allow for these Medicaid waivers to be put in place. And the Medicaid waivers are managed either through the DD board or through Job and Family Services themselves through Medicaid. The DD board provides the IO waivers, the level 1 waiver, and the self waiver. Job and Family Services provides the home care waiver, assisted living waiver, and the passport waiver. The income limit for these programs is 300% of the SSI rate, or $2,901 a month in 2025. So you can be making $2,900 a month and still qualify for a Medicaid waiver. Another Medicaid program that's fairly new, Medicaid Specialized Recovery Services, or SRS. You can receive Medicaid and have a high income if you are suffering from a severe and persistent mental illness or a chronic condition. And there's a whole list of chronic conditions that one can be suffering from. This just opens a lot more doors for people that they don't have to worry about that income limit. If they're making $2,500 a month from Social Security, well, you can still qualify for Medicaid using this service. There is no asset limit for this Medicaid. So you can have $1 million in the bank receiving $2,000 a month and still be on Medicaid to pay for, your care. Another important program that Medicaid provides is this buy-in for workers with disabilities. So what Ohio and many states, say is, hey, understand that you are receiving a low amount of income, but we also want you to work. So being in this program, if you're working on Medicaid, your asset limit won't be $2,000. It's going to be $15,210. And you're able to make more money as well. So we understand that you need Medicaid, but we also want you to work. So this is, the state saying, hey, we want to provide you with as much support as we can, and we want you to work. So that's why this program was approved. There may be a premium based off of income. Um, I've seen premiums, it varies. I've seen $5 a month to $20 a month. So it doesn't make much sense, but there's a small premium possibly if you're in this program. So SSI, just a little bit more on SSI. SSI was intended or is intended to pay for the beneficiary's food and shelter. You have to have low resources, less than $2,000, not have a work history, and the representative payee can be appointed to receive this money, whether they're on SSI or SSDI, and they can manage this money for the individual. So can that be the trustee of their special needs trust or their third party trust? Yes, it can. It can be someone else. It can be a facility. As long as this person is using or this facility is using this money for their benefit and reports that to Social Security, then that would be protected. So we still call in-kind support and maintenance the food and shelter rules. But new rules have been in effect with Social Security, stating that if you use or if someone pays for food for this individual, that's going to reduce their SSI by at least a third, or the maximum to a third. But now the rule is they took out that food rule. So it's now just shelter. So if mom or dad or trustee is paying for shelter expenses, then that's going to affect their SSI, but food is no longer. Ohio is still lagging behind that definition, but we've seen some, some wording out there that they're going to change that to mirror the Social Security rules. Here's just examples for you, just so we can illustrate. If John receives SSI, John's mom gives him $50 every month for online gaming. That's countable unearned income. So he didn't earn it. So SSI will be reduced by $30 each month. So $50 minus the $20 disregard. If John's mother, trustee of his special needs trust, gives him $50, we have the same result. It doesn't matter where the money is coming from, whether it's a trust or from an individual, they're going to be, affected. Here's another example. John's mom pays his $900 rent. That's a shelter expense. So his SSI will be reduced by $880 each month. But John pays $343 towards his rent. His mother or his trust pays the remaining $557. His SSI will not be reduced. So payment of shelter by a third party reduces the SSI if the recipient doesn't contribute at least a third, which is in today's value, $342.33 towards shelter expenses.
I'm sorry, Ethan, did you say this isn't valid in Ohio yet?
So the It's the food portion hasn't been updated for under the regulations. So that's Ohio is still lagging behind the food portion of it.
Ethan, so
Yeah.
if a working majority age child is living with you and pays you rent,
Mhm.
food expense, but the rent in excess of $343, that's not reportable, the SSI is not reduced.
It's reportable. You have to report it to prove it, but the SSI will not be reduced then. So you have to have a room and board agreement, some sort of arrangement with them, with the beneficiary to prove that, yeah, beneficiary is paying me money. Here's the receipts. Here's our agreement.
Even if that money is coming from,
It should be coming from their SSI. It needs to come from their SSI. Yes. And what that parent does with that money, that's up to them. If they want to set it aside for that individual, they can do that. Or if they need that money to pay for their expenses, then absolutely they have to use that money to pay for the expenses. But now you're taking the first party money, now it's mom and dad's money, and they can do whatever they want with that money then. So typical transition timeline, well, before I get into this, the shelter rule would not come into play if the child resides with the parent and pays their fair share of rent. Yes, that's what I just explained. Okay. So typical transition timeline, when because a lot of things happen at age 18. Now this child is becoming an adult. Um, What we see is the parents' income no longer deemed. Now they're eligible for SSI and Medicaid. The parents are no longer the legal decision makers for the child. So we have to talk about guardianship. Or is there alternatives to guardianship? Does a power of attorney, can that come into play? Um, then we have the payment of the food and shelter by the parent is categorized as unearned income to the child. All of that will need to be discussed because then we decide, yeah, this child is living with parent. We need to do a room and board agreement in order to make sure that this child is receiving the maximum amount in SSI and that child pays mom and dad for living in the home through that room and board agreement. And like we just talked about, that money can be used for the household or it can just be set aside for that child, whether that's put into a third party trust or just set it aside in an account to be, earmarked for that child. So child's on SSI, then parent retires. So this is just a recap of what we already talked about. If parent retires, child is now eligible for childhood disability benefits, which is the DAC, disabled adult child benefits. Child would receive one half of that parent's benefit. So child's on SSI and Medicaid. Parent retires, receives $4,000 a month in Social Security retirement benefits. Because that child is disabled before the age of 22, that child will now receive $2,000 in SSDI based off that parent's work history. If that parent dies, that amount is shot up to 75% of the parent's work history. So the child would receive $3,000 a month. Because they are eligible for SSDI, they're also eligible for Medicare. So at the end of the day, they're going to receive a higher amount of income. They will receive Medicare and they will also keep their Medicaid benefits because Medicaid disregards child disability benefits as income. So they will have more benefits, will open up once a parent passes away or dies if they are considered a disabled adult child. which is why I stress go get them SSI as soon as possible when they turn 18, at least before the age of 22. So you have that determination that this child is disabled before the age of 22. So the types of trusts we use to ensure that these benefits are protected. This is one broad concept that we use for these two trusts. It's a third-party trust or a first-party trust. They are administered the same, essentially. They both have wholly discretionary provisions that the trustee has the sole discretion to use or not use these funds for the beneficiary. There's only one beneficiary so this money is for the benefit of this one person. The only difference is when this beneficiary dies, is there a Medicaid payback or not? With a first party trust, there is. A third party trust, there is not. So third party trusts, they are enacted through the revised code. These are assets that are funded that have never belonged to the beneficiary. So this is mom and dad, this is grandparents, this is money owned by family members. I could contribute money to this child if I wanted to, or to this child's trust. The assets should never have belonged by that beneficiary. So that's why we call it a third party trust, because these are funded by third parties. It's available as a resource if the trustee can spend the money, if it says in the trust that the trustee can spend the money for the medical care or care, comfort, maintenance, health, wellness, or general well-being. The Job and Family Services will say that this is a countable resource because there is an ascertainable standard. That's why in our trusts, we leave it very simple, very basic. The trustee has the sole discretion to use or not use this money for the benefit of the beneficiary. It's also useful Medicaid planning for parents and grandparents that need Medicaid themselves. If they need to go to a nursing home, they can apply for Medicaid by transferring all their assets to a third-party trust, because Medicaid regulations allow that. They allow for exempt transfers to a disabled child or a disabled child's trust, and they themselves can get on Medicaid. That's what we call a sole benefit trust. So a sole benefit trust, it's the same as a third-party trust. It has a little bit a longer provision in there about the sole benefit meaning definition. But it's in essence a third-party trust. So there's no waiting period. You don't have to worry about the 5-year look-back period. If I need to go to a nursing home and I have a disabled child, I can transfer all of my money to my disabled child or to a sole benefit trust, and that is an exempt transfer for Medicaid purposes. And it's not counted as an asset for the beneficiary. So it's a win-win for everyone. It's a win-win. It's a win for the state as well, because, hey, if there's more money set aside for a disabled individual, that's, in theory, less money that the state has to provide for them as well. Self-settled trust, Medicaid payback, first party, special needs trusts. I know we give it a lot of names, but that's not our fault. That's just everyone having an issue with naming these types of trusts. This is used for funds which the disabled person owns directly. So they received an inheritance directly to them. They receive litigation proceeds. They were involved in a personal injury suit. They receive child support in a castle case. Or this was an improperly drafted third-party trust that the state or Social Security has said, this is a countable resource. I don't know what you're doing. You have to put this money in a special needs trust now. These types of trusts have this Medicaid payback. They can be established by, there's the code sections in the federal statute says it can be established by a parent, grandparent, the guardian, or the court if they're involved, or a competent adult can establish it themselves, who's the beneficiary. You can establish this if you're disabled and under the age of 65. And of course, it has that payback provision at the beneficiary's death. There's also, instead of a self-settled trust, there is a pooled Medicaid payback trust, which is used by a nonprofit organization. We use a company called Community Fund and the Dayton Foundation. There's 2 in Ohio. Every state has their own rules with pooled trusts. These pooled trusts, like I said, are managed by a nonprofit. A corporate trustee, such as Huntington Bank, is a trustee. And the nonprofit is what's called the trust advisor. They are in charge of making distributions and management of the money. And a designated advocate is appointed, and that could be like a family member, to request distributions on behalf of the beneficiary and receive statements and just keep involved in the money. So obviously there's less direct family control, but also less responsibilities. The pool trust takes care of the investing, the taxes, and making sure that reporting requirements are done to the agencies. So I really wanted to talk about stable accounts, so I'm glad we're here. Stable account, which is the ABLE Act. ABLE is the federal statute. There's been some changes just recently within the last month with ABLE and stable in Ohio. But just as a recap with the ABLE Act itself, it was passed in 2014 to allow for states to establish these accounts for disabled individuals. There was a need by the disabled community, and there was a need by us as attorneys that if someone was receiving $10,000, why go through the hassle of opening up a special needs trust when we're only talking about $10,000? I mean, it made no sense. Why spend thousands of dollars in attorney fees and time to do this trust work when we're talking about such a limited amount of money? And plus, if a beneficiary who receives SSI is receiving, they're over that $2,000 threshold a month and they have nothing to spend the money on, why are we spending money on stupid stuff to get them below that $2,000 threshold? So for those reasons, that's why it's like the stable account has been enacted. This originally, the bill said there was no limitation on the beneficiary's age. The yearly contribution was equaled to the 529 cap, and it would cost $19 billion over 10 years to manage. They scaled it down significantly. This is the 2014 version. It would cost $2 billion over 10 years. There's IRS regulation history that we won't get into. The statute for Ohio, which has been updated, is that 11350. So you have to be blind or disabled to be eligible before the age of 26. Beginning January 1st, that requirement has been changed to 46, starting January 1st, 2026. So in a couple months, they upped the age. You have to be either receiving Social Security benefits based off of a disability or otherwise meeting the Social Security disability test. So it has been that you just self-attest that you've been disabled before the age of 26. Now they're requiring a form to be submitted by the doctor. The self-attesting form has to have also a doctor's note saying that, yes, you've been disabled, you know, before age 46 or 26, whatever the case may be. You can only have one ABLE account, and you don't have to reside in the state where the ABLE account is open. So technically, in Ohio, you can go to New York's stable account and open an account, but you can only have one stable or ABLE account throughout all the states. Ohio, to be honest, Ohio is one of the best. They have one of the best investment options. You can invest up to 5 different options, either a savings option or a investment options with Vanguard, and it could be the riskiest to the most conservative investment portfolio. So there's a lot of options that you can use. The otherwise, here's the otherwise, meeting a disability test. That certification must be submitted to ABLE. This is only for new accounts that will be open. So establishing the account. So ABLE accounts can be opened by the beneficiary themselves or the beneficiary's parent, guardian, power of attorney. Really, there's these are the main people that can open the account, but there's also, group homes can open an account. The facilities can open an account for the individual. So there's more, but these are the main people that can open the account. Contributions. So any person can contribute to an ABLE account. So by person, that can be, a trust, that can be a corporation, that can be a person. The change in beneficiary is allowed for siblings. And rollovers can be done from other ABLE accounts and from 529 accounts. So I have many clients come to me and say, hey, I have a 529 account with my disabled beneficiary. I didn't know if, we weren't sure if they were going to go to college or not. We just contributed this 529 account. You can contribute you can roll over the 529 to the stable account, but it's only limited to the annual contribution limit. So that's the next slide. $19,000 per month or per year, excuse me. So if the 529 account is at $100,000, you can roll that over, but only $19,000 per year. And there's contribution limits in total, which is the next slide. But the state limit for in Ohio is $555,000. That's the maximum amount that can be in there. Excess contributions must be returned to the contributor. So if there was $25,000 deposited into the stable account for 2025, well, $6,000 has to be returned. The impact on this stable account with SSI and Medicaid, well, SSI eligibility says the first $100,000, or there's a max of $100,000 that can be allowed in a stable account. If it goes over, then it starts counting as a countable resource, anything in excess of $100,000. Medicaid, there is no $100,000 limit. It can go beyond that. So you're really only looking at the SSI eligibility. But this is the big news. So effective September 30th, so just a few days ago, stable accounts are not subject to a Medicaid payback, a Medicaid reimbursement at the beneficiary's death, unless subject to federal law. We're not really sure what that means, unless subject to federal law. But from all the, materials that we've read and that we've seen, that there is no Medicaid payback on stable accounts. So essentially what would happen is it would go to the beneficiary that's, attached to the account, or it would go through the stable accounts beneficiary's estate, and it wouldn't go to Ohio can have a claim, but they won't be paid because of the new rule. So there is no Medicaid payback anymore, at least we think. So it's still up in the air. I'm just going to address this question right here. I was told that my special needs brother did not have the capacity to sign giving a power of attorney. Any way around this? Yes, there is. I mean, it depends on what his disability is. If the capacity can come in and out, only a court can determine whether a person's incompetent or not. And incompetency comes with a guardianship. So if I, for example, would meet with him and say and have a general conversation about powers of attorney and whether he can sign his name, I might say that, yeah, he has the capacity to sign, and I would notarize it. Um, if the child receives one half of one parent's benefit, will it switch to a higher amount when the second higher earning parent retires? Yes, it always goes to the highest earner. So if dad retires, he makes $3,000 in Social Security benefits, and mom retires 5 years later, she's receiving $4,000 in benefits, it would go to the higher amount. Does a DAC payment greater than 2,000 a month lose Medicaid? No, and I think you're confusing the $2,000 asset threshold with income. The DAC payment is disregarded as income, so they will continue receiving their Medicaid benefits. When I start collecting Social Security, will my disabled child before age 22 son who gets SSDI draw the additional amount from my Social Security? Half would be much more when he gets today. If so, how much would it impact my wife's ability to draw my Social Security? So there is a limit on what the family, it's called the breadwinner. If the family is receiving Social Security from one breadwinner, it will be prorated between the disabled children and the spouse. That their payment will be reduced depending on if they're all receiving benefits from the breadwinner's work history. The breadwinner's Social Security will not be changed, but his spouse and his disabled children would possibly be changed. All right, I answered that question. No, step parents are not included in the DAC. It is the blood parent. I recently sold my sister's condo and had the money wired into a trust account. Should I change that to a stable account? I mean, you can always deposit money to her stable account now from the trust. So a trust can fund a stable account. And really, that's what the way I use stable accounts for my clients, and for my beneficiaries, is it's a spending account. And it changes the ball game now that it's not subject to a Medicaid payback as well, that I can fund from the trust to the stable account on a monthly basis. And this beneficiary now has access to money that they otherwise don't, and they can use this money freely for whatever they want. So it all depends on the circumstance, of course, and whether that person is able to use the money appropriately. But if they are, then that's great. It gives them more financial freedom to go do what they want to do. I can have a watchful eye over that money to make sure that, yeah, no one's taking her card and spending money inappropriately, that I can stop that if that's the case. But if they're being responsible with the money and I can trust them with the money, then yeah, I'm going to do that. And I can do that up to $19,000 per year. So here's $1,000 a month and go do what you want to do with that. And if you want to use that to, up to help with your rent, you can do that. And that's not going to affect your SSI either, because a stable account will not affect SSI. The stable account is in that person's name. It's not coming from a third party. Yes, it is initially coming from a third party, but the stable account is in their name. They can use that for food or shelter expenses and not have their benefits being terminated or reduced.
If it's in their name, is that more than the $2,000 asset?
Stable account is an exempt account, so up to $100,000, it's exempt. So that answers this question: is a stable account considered an asset? It is up to $100,000 for SSI. For Medicaid, up to $555,000, and you can't contribute any more than $555,000 to the account. All right. When funding stable from special SNY, not really sure what that is. Okay. So back to more about stable. What are qualified disability expenses that can be paid from the stable account? Well, that's expenses that are related to the beneficiary's disability, are for the benefit of that beneficiary in maintaining or improving his or her health, independence, or quality of life. So what does that tell you? As long as the money from the stable account is being used for that person's benefit, then you're good. It doesn't have to be just for medical support or shelter support. If the beneficiary wants to go on a trip to Cedar Point, to Mexico, yeah, you can use the stable account money for that. So entertainment, vacation, as long as it's being used to benefit that beneficiary, the stable account can be used for that. So this is just more examples of qualified disability expenses that can be used from the stable account, which is, why I love using it. It's for my beneficiaries, for my clients, that they can go do what they want to do with this money. They would have had this money anyways from their injury suit, from their mom and dad. And this is a way to get them at least some of that money on a regular basis that they can go do what they want to do, and they don't have to go ask the trustee for permission to, hey, can I have $500? How are you going to send this $500 to me? I don't know. I don't want to lose my SSI benefit for this month or next month. Well, now you don't have to worry about that. You can just put the money right on their stable account and it will be linked on their card and they can go, do what they want to do. It gives a lot more financial freedom. So with that, let me look at the questions one more time here. Does the beneficiary get a K-1 when an S&T funds a stable? Yes. Well, that's from the special needs trust. So the trustee and their accountant would provide a K-1. The distributions to a stable account is a distribution for the benefit of that beneficiary. So that would be considered a distributable net income to the beneficiary. Yes.
Stable account, a better substitute for a special needs trust?
It depends. If we're talking about less than $19,000, then yes, I get a call probably once every month, every 2 months from a personal injury attorney that says, "Hey, this my client of mine is receiving $15,000 from a car accident. They're on SSI and Medicaid. I know the PI attorney always tells me I don't know what I'm doing here, but I know they're on benefits. I think they need a special needs trust." And I say, "Well, are they competent?" And they say yes. "Well, why pay me to go do this trust for you when you can just put this $15,000 into a stable account and their benefits are protected?" So it all depends on the amount of money that needs to go to protect the benefits. If it's more than $19,000, the person's receiving $30,000, you can still utilize a stable account, but you have to spend $11,000 then within that month's period. So sometimes they say, "Well, I don't have anything to spend." The only way to go about that is to do a special needs trust then. So it all depends on the amount of money and what the circumstances arise. Let's see here. All right. Well, I think that's everything. Oh, no, that's all. Well, thank you, everyone. Like I said before in the beginning, we will upload this. Just give us a week or so to get that processed. And it was very nice meeting you. Thank you for the people that came, and we'll do this again in 6 months. Thank you.